A process for First Nations economic development is missing. Chief Nolan then participated at the U of T session on May 1st, 2008. Doug Sanderson, professor who teaches Aboriginal law and property theory in the Faculty of Law at the University of Toronto, was the organizer, and there were two moderators, Darlene Johnson, U of T, and Shin E. May of Osgoode Hall. Professor Sanderson described the event of May 1, said it was very well received, and people who were there looked at a host of economic development models for various First Nations scenarios. Rupert Ross participated, the Crown Attorney in Ontario and author of titles including Dancing with a Ghost and an examination of the remarkable disconnect between First Nations and the Canadian justice system. He was the opening speaker. Right Honourable Paul Martin, former Prime Minister of Canada, champion of the Kelowna Accord that fell with his government, which accord was accepted by the Assembly of First Nation Chiefs but dropped by the present government, spoke at the end of the conference. Aboriginal economic development as an academic exercise was national in focus. I think the most important thing is that everyone recognizes First Nation economic development as a political matter, said Sanderson. This is an important distinction to consider. The politics, say, essentially one race of the Canadian mosaic is positioned outside the realm of mainstream economics. This would explain why poverty is the main issue separating First Nations from mainstream Canada. For no opening exists to permit the entry of First Nations into the bulk of Canadian law, which is commercial law. The Indian Act does not allow it. Sanderson said the situation is made the worse by the settler versus Indian mentality, a split that prevails in the Canadian court system across the nation. As long as the political situations remain unresolved, and while certainly solutions are currently being sought, people are now beginning to address economic matters at the political level. The term in vogue at present, while real solutions are contemplated, is called certainty. Sanderson said there are many ways for First Nations and corporate Canada to act together, ways to do economic development. The current political reality demands the thought and speech gravitate around ways to do economic development. In fact, experts like lawyer Herb George, Satsan, president of the National Center for First Nation Governance, stated, "Every act of economic development is an act of jurisdiction. It is jurisdiction that makes entities behave in certain ways and sign into impact benefit agreements. These agreements are signed between mining companies and First Nation communities in Canada in order to establish formal relationships between them to reduce the predicted impact of a mine and secure economic benefit for affected communities," wrote Irene Sosa and Karen Keenan, October 2001. IBAs are increasingly used by First Nations in Canada to influence decision-making about resource exploitation in their lands. Impact benefit agreements between Aboriginal communities and mining companies, their use in Canada, by the aforementioned Irene Sosa and Karen Keenan.